We're really glad that you're able to be here with us today, and we hope that you find this session really useful. I want to introduce my fellow speakers this morning. I'm Sonya O'Reilly. I'm a partner in the employment team at Burkitt's, and I'm joined by my colleagues, Sarah Bull, a partner in our London office in the employment team, and Charlotte Sloan, one of our legal directors based in our South East area, working out of Sevenoaks. We're going to guide you through some thoughts today around how to navigate exits with employees, and we're particularly thinking about how to do that in ways which might be a little bit more commercial sometimes, and how you might deal with that as you navigate these sorts of issues. So the things that we're going to be discussing are as set out on the screen there. So we're going to talk about how to get the most out of an exit conversation. We're going to look particularly at without prejudice issues. So there's quite a bit of legal content in this session, and that's because there are some real complexities around when you can have certain kinds of conversations with individuals when you're not following full process and procedure to effect a dismissal. So we're going to look at some of those legal issues around without prejudice and the rules on that, and also the rules that are set out in the Employment Rights Act 1996 in section 111A of that Act. We're going to try to bring it alive for you with some cases as well, so that you can understand how these things happen in practice. And we're going to talk as well then about protected conversations and the sort of do's and don'ts and pros and cons of having those kind of conversations, all of which we hope you'll find really useful. In terms of questions, we have tried to formulate our presentation and webinar to you today based on some of the questions that we've had in advance. So hopefully, though, the materials that we're going to share with you will cover a lot of the thoughts and questions that you might have had in your minds about these issues. But if actually we don't cover anything, and if we run out of time at the end and don't have time for live questions, please do feel free to email one of us with your questions, and we will very happily try to respond to you as soon as we can. Our details are going to be shown at the end of the presentation, and you'll have QR codes and our contact details so that you can get in touch. Let's start with our first particular section that we're going to look at, and talking really about the kinds of tools that you have in your toolkit if you're trying to effect an amicable exit. Now, of course, the first thing to say is that normally speaking, if you're going to terminate an employee's employment, you would be following fair process and procedure to do so, and you would need to have a fair reason to bring about that dismissal. And of course, we could be talking about all manner of different dismissals, but today's session really is about looking at what are you going to do if you're trying to effect a dismissal in a way which short circuits some of that process. How do you go about trying to bring about an exit in as amicable a way as possible, but without going through all the formal and legal processes that you might normally need to follow for a capability dismissal or a conduct dismissal, or indeed any dismissal that's permitted in law. So what other options do you have available to you? Some of which you may be familiar with, and you might have used them on numerous occasions. Particularly, most people are familiar with the concept of a settlement agreement. So a settlement agreement is one of the ways in which an employer can bring about the termination of employment of an employee and the settlement of any potential claims that that employee might have had against the employer. In fact, in law, there's only two ways to settle all statutory claims that an employee might have against an employer. So by statutory claims, I mean things like unfair dismissal claims, discrimination claims, whistleblowing, all those sorts of claims that you may be familiar with. But they can only be settled in law by a particular form of agreement, which is either a settlement agreement, and that has to be brought into effect with the individual then going and taking independent legal advice on the agreement that they're signing, so that they can understand the rights and the obligations that they're signing away. That's one form of agreement, and it's one of the things in your toolkit for being able to bring about an amicable exit. And we'll talk about how you do that as we go through the session. The other option that's sometimes used is a slightly more complicated form of settlement agreement, and it's a settlement agreement which is in two parts. So the first part would be signed when you come to an agreement with an employee, but if actually their employment is going to continue for a period of time, perhaps they're going to work their full notice period, and if that notice period is perhaps a 3-month notice period, you might then also want to make sure that any claims that could have arisen during that notice period are also going to be covered. And that can be done by getting the employee to sign what's called an affirmation letter, or a second part of a settlement agreement at the end of their employment. That's quite commonly done. And actually, there's all sorts of reasons why that can be useful. It can keep somebody bought in to the employment as well during the period of their notice, can keep them engaged because they're only going to achieve the financial sum that might have agreed in the settlement discussions if they sign that second part of the agreement as well. So that's another potential option. One that doesn't actually bind the employee, but might have a deterrent effect from the employee bringing any claims, is asking them to sign a letter which simply states that they are not going to bring any claims against the employer. Again, we'll talk about whether that's a sensible thing as we go through today's session. But it is important that you note that just a simple letter can only sign away contractual claims. It can't mean that the employee would be prevented from bringing any statutory claims like unfair dismissal or discrimination. Those would be, those sorts of letters would only be sort of morally binding almost. So it's a deterrent effect, but not actually legally enforceable. And then the final tool in your toolkit when you're looking at sort of commercial ways to effect an exit with somebody, hopefully in a more amicable way, is something called a COT3. That's an agreement which is done by using ACAS to assist in the process. It means that the individual employee does not have to go and take independent legal advice, which can be useful in some circumstances if you're a little bit loath to send somebody into the arms of a solicitor. It can be a conciliation process which is led by the employee, if the employee is asking to try to see if there's a mutually agreed exit that can be arrived at, or the employer can suggest it. And we'll talk about those forms of protected conversation as well as we go through today. So why might you even want to talk about this? Why might you have issues that you want to discuss in terms of exiting an employee early, or indeed exiting them without going through full process? Well, there can be all sorts of reasons why that might not want, you might not want to go through full process as an employer. Normally, of course, there could be reasons for exiting an employee. Could be because you're looking at restructuring the organisation. It could be because there are performance issues that haven't been managed particularly up to this point. Could be clashes of personality between the employee and members of the team. Now, of course, there are correct and legal processes that you could go through to manage an exit of an individual properly, through a capability management process, a redundancy process, changing terms and conditions, or indeed capability. All of those sorts of issues can be managed properly. And of course, that's the sort of gold standard in law, to manage things correctly. But where the employer wants to see if there's a way of dealing with it in a slightly quicker fashion, then there can be routes to do that. And those agreements that I've just talked about are the ways that you could potentially have conversations with somebody that would result in an exit in a different way. Those sorts of problems that you might otherwise face could be avoided if you can then encourage somebody to enter into a mutual discussion with you, which would result in an amicable exit under one of those kinds of agreements, a settlement agreement or a COT3. And if you can do that, then you can avoid the risks that come with an employee who has had their employment terminated, who is really disgruntled, who is looking at potential claims that they might be able to bring. And that, of course, has real costs in terms of potential litigation costs, negative publicity, legal fees, and the time and management time that can be taken in dealing with somebody who has left your organisation but has left in a way that is causing upset and difficulty. So it can be really a useful tool to try to see if you can exit somebody where appropriate without going through all the full legal stages. There are, of course, some risks with having these conversations with people which are not part of a proper legal process. If there has been no conversations up to that point in time with an individual about either concerns around performance or concerns about the need to manage somebody's ill health or their conduct, or if there's been no redundancy process or restructuring process which has started up to that point, then it can be risky to start these conversations straight out. There needs to be a dispute, and that's something that that we're going to explain and talk to you about as we go through the session. But there are some risks that I just want to flag right at the outset, and those are as set out on the slide. Firstly, it could be a breach of contract to start having those discussions with somebody. And that's really because of the danger that in starting to suggest to somebody that, well, rather than go through a formal process with you, we'd really like to have a conversation about how you might leave the organisation in an amicable way, perhaps with some money to go. That starts that employee feeling that you absolutely don't want them there in the organisation anymore. And that could amount to a breakdown in trust and confidence. In all likelihood, it does amount to a breakdown in trust and confidence, which can be really challenging. It could mean that the employee might resign in relation to that breakdown in trust and confidence, and then you have a potential constructive dismissal claim on your hands. That's fine if you're prepared to pay the compensation that that individual might be eligible for under any kind of settlement. But if you want to try to negotiate it in a way that tries to minimise your exposure to the amount of money that you want to put forward, then you need to think about it really carefully. It's also important to bear in mind that if you're going to start that conversation with somebody about exiting them from the organisation, and there hasn't already been any discussions with them about an existing dispute in any way, or an existing grounds of restructure or redundancy and those sorts of things, then it's open to the individual to start to search around for the kinds of things that they might think have caused you to come to the decision to exit them. So they might start looking around for other things like discriminatory reasons, and they might well be concerned that the only reason that you want them out of the organisation is because they've blown the whistle or they have raised issues of concern, they've raised a grievance, those sorts of things. And that can mean that you are again opening your organisation up for enhanced amounts of money that you might end up having to pay by way of compensation. There are also concerns about evidence in these conversations. And that's going to be entered into in much more detail by my colleagues when they're speaking to you about the need to make sure that you have these conversations in a particular way so that it's protected. Because otherwise, if you don't manage to achieve a settlement, the individual might well be able to draw to the attention of a tribunal the fact that you were trying to get them out by a non-legal route, as it were, a commercial route. And that can be damaging from an evidential point of view. Also, it's worth just noting here as well that there can be limitations for certain organisations in their ability to enter into these kind of agreements at all. So you do need to be very cautious about that, particularly in the education field, if there are, or indeed any organisation where there may be safeguarding concerns about the individual that you're trying to exit. In those sorts of circumstances, there are a number of rules that are particularly related to whether or not you can even have any settlement discussions and enter into settlement agreements or COP3s with somebody where there are safeguarding concerns. That's outside the scope of detail that we're going to be covering today. But if that is something that is of concern to you, then again, please do reach out and we'd be very happy to advise you further. Again, in the public sector, there are also particular limitations around managing public money and your ability to make payments to people where it's perceived to be a reward for poor performance or poor conduct. And so there are limitations on what you can do in those areas as well. So again, if that's relevant, then please do reach out and we'd be very happy to talk to you individually about that. I'm going to hand over now to Charlotte, and she's going to take you through our next session on how to get the most out of those exit conversations.
Good morning, everybody, and thank you, Sonya. So as Sonya says, I'm going to be looking at how to get the most out of those exit conversations, and typically where you're leading up to a settlement discussion. So we move on to the next slide. I've set out a good way to approach that conversation to get to the point of a settlement offer. However, I should just say from the outset that there isn't necessarily a one-size-fits-all approach, and it will depend on the circumstances. And this approach that I'm going to be setting out to you right now will need to be tailored appropriately to the circumstances. You may also want to take certain shortcuts that may come with some degree of risk, but commercially that may be the best outcome for you. What I would say to you in those circumstances is just get some advice about what is the best approach, what are the risks if we do take these shortcuts, and particularly you might want to be relaying that to management or get them involved in a call with your lawyers so they understand what the potential pitfalls could be, and they understand that if this all goes horribly wrong, they might need to be prepared to get their checkbooks out. So I would make sure that they are involved and understand that approach, and particularly if you're getting pressure to just go through this process quickly to get to the outcome of a settlement discussion. So typically you will give some warning to an employee about the fact you want to meet with them. Now that may not be appropriate in all circumstances, particularly where you're concerned that there's a risk the employee might go off sick. If you sort of say you're being called to a meeting, if they kind of can see that the writing might already be on the wall. However, if you can give some kind of notice, that can be really helpful, and make sure that they aren't really a big surprise when they're called into a meeting, and make sure that meeting going forward goes as smoothly as possible. Subject to what process you've carried out previously, there may already be a process you're going through. So to give you a plan B, and Sarah will talk some more about that. But even if you're launching into a discussion about settlement, you might still want to set the scene. So you might want to explain, here's the relevant evidence and the process we've been through to date. So make sure you're familiar with that process, gather the relevant documents so you can refer to those in the conversation, and just really know what the issue is, what your company policies are in relation to that, so you can explain the circumstances and help with your negotiation power really in those discussions when you present the settlement offer. It can be really helpful to prepare a script for that meeting, something we quite often get involved in when we're advising our clients. A script should just really be guidance notes, so points that you need to cover off in the discussion. You won't be a verbatim script exactly how you need to say it. You need to be prepared to go off script. So if you've got a manager who's running the conversation, you need to give them that clear understanding that they need to be prepared to adapt what is in the script to the circumstances. But it can be really helpful to make sure you cover off the salient points. I also find it can be quite helpful to make sure that managers know what points not to bring up or how not to say it in a particular way. So again, that can be really useful just to give them a bit of guidance. And if you've got lawyers preparing that for you, they can prepare it for you on a legal privilege basis. You just need to be careful that the manager isn't making notes on that document, which may mean that document is potentially disclosable in any proceedings. We can touch upon that some more in due course. Conducting the meeting face-to-face is advisable if you can do it. If you can look the employee in the white of the eye, you can read their body language, how they're responding to the proposals you're putting forward. That can be really helpful. Doesn't necessarily need to be in person. It can be over a Teams call, video call, but in the circumstance where you can see them is really helpful. And you may also want to ask if they want a companion with them. It may not always be appropriate for them to have a companion with them, but it can just help make everyone feel a bit more comfortable. And equally, from the organisation's perspective, it can be quite useful that you've got two of you there present, because you've got somebody there who can be a witness to what was said or what wasn't said if there is any dispute later on. I guess I'm sure you'll all be very conscious of this anyway, but just be aware that sometimes these conversations are difficult. And obviously, you need to be sensitive to the fact that this may not be something the employee was expecting or wants, or a route that they were expecting at all. Just be conscious of that, be sensitive, and also just be conscious of the surroundings. It's going to be a difficult conversation potentially. Are you in a confidential space? Are they in a room where they're going to be constantly interrupted? That's not ideal, obviously. And if you're in the workplace when you're having this conversation and you're in a room, are they going to have to go back into a room full of people, potentially a little bit upset about how this conversation's gone? So just be aware of that and try and make sure you're in a place that is private and an uninterrupted setting. I've got to communicate the decision, and that will depend on whether you've all carried out a prior process with them more formally. So that may not be relevant, but it may be something you can reference as part of the context. But then you're getting into the crux of here's our settlement proposals, and you want to make sure that you head that appropriately without prejudice, or it's a protected conversation. Again, Sarah will talk to you some more about that. But summarise what your proposals are. And I put here summarise the financial offer, but in addition, summarise any other key points that you think that might persuade them and be useful. And I'm going to talk a little bit more about that in a bit. So any beneficial terms that you're offering, talk about that. And if there is any room for movement, if there is some negotiation you're happy to be having with them, make that clear, because you're just being transparent with them. You're setting the scene, you're giving them that power, and make them feel hopefully more empowered and amicable about the situation. Give them some time to consider the proposals. Don't pressurise them into accepting and signing something straight away. They won't be able to do that if they sign a settlement agreement in any event. Typically, 10 days is usually advisable to give the employee to consider the proposals. But again, there may be circumstances where you need to adapt that and have a shorter period. If it's a settlement proposal, you will want to provide a copy of that settlement agreement and perhaps follow up with the meeting with that. You may have it to hand already, but typically it's a bit better if you provide that afterwards. You've had the meeting, you've had the conversation, you've sounded the employee out on the discussion, and then if they seem interested, you're then following up with that settlement agreement rather than having something pre-prepared that you can wave at them and present to them at the meeting. If it's a settlement agreement, they need to get legal advice in respect to that settlement agreement on the terms and the effect of the agreement. They may already have some thoughts as to who they might get in touch with, but you might want to suggest that you could always ask your lawyers if they've got anybody recommendations they can make for an independent advisor who could help them with that advice. Again, just to help them feel comfortable with what the process is. Move on to the next slide. I just wanted to sort of go through a few terms that can be really useful to help persuade an employee when you are presenting a settlement proposal to them. Ex gratia payments, so the actual compensation is obviously quite a key term. So think about what you're presenting to them. Have you got some wriggle room as well? So it's typically a good idea to have some form of movement, so the employee again can feel that they are empowered in those discussions. So don't always go in with your best offer. Don't go in with an offer that's so ridiculous that clearly the discussions are not going to go very far at all, but just try and think of that middle ground. And again, it's something where it's usually a good idea just to get some legal advice as to what's their potential claims and what would be reasonable to try to resolve this issue. But it's terms beyond just the financial terms can also be really persuasive. So is there anything else that you're prepared to offer that can help encourage the employee to accept what you offer, and you can all resolve this in an amicable way? So outplacement support, can you offer them any support with CV writing and helping them find another job? Can you offer an agreed form of reference or an agreed form of announcements? You've got to be a little bit careful if you're in a regulated sector, and I know quite a few of you on this call are in the schools, in the education sector. So with that, just be conscious of obviously the limitations of what you can do within your sector. But a reference, as long as it's factually correct, which sometimes goes beyond just the dates of employment and a job title reference, can sometimes be something that can be quite useful to persuade an employee to accept the overall deal. Equipment can also be something that you can use as a bargaining tool. So if you're offering the employee the opportunity to keep any form of equipment that you've provided to them during the course of their employment, Things like mobile phones typically come up in discussions. Can I keep that mobile phone and the mobile phone number? It may not always be appropriate for them to do that. You may have concerns that if they've got the same mobile number, clients or contacts may get in touch with them, and that may be in breach of their restrictive covenants. But if it is something that's within your gift, it can be quite a useful tool. Thinking about the notice period, it's also something that can be worthwhile doing when you go into these discussions. Could you offer the employee the opportunity to be on garden leave during their notice period? Or could you pay them in lieu of notice rather than them having to work out their notice period? That can be something, again, which can be quite attractive to an employee when they're thinking about the overall deal. I mentioned restricted covenants in the context of the mobile phone, but also just think generally about the restricted covenants. To what extent do you need them? If an employee is bound by restrictions, which may make it difficult for them to find new employment, could you potentially agree to waive any of those restrictions? So what I'm really talking about is those non-compete provisions that prevent them from joining a competitor. Is that a deal breaker for you? Is that a problem? Or could you be generous and allow them some leniency and waive that because it's not going to cause you any problems, but it helps them in coming to terms with the deal that you're offering? You might also want to think about your warranties that you include in these settlement proposals. So with warranties, if you've got any warranties where the employee... So a typical warranty that you have in a settlement agreement is a warranty that the employee hasn't already got any other job offers. And if they have got any job offers, that may mean that the proposals, you're not offering the deal anymore. That may be something you're prepared to negotiate on, because actually to create that amicable solution, you're prepared to waive that warranty in respect of not having any other discussions already underway in respect of other roles they might be taking. So the final few points, I've got mutual waiver of claim. That can be another really useful point. So often where you're having discussions with employees and there's allegations levied on both sides, the employee may feel that they're prepared to sign up to a waiver of claims on the basis of the terms that you're offering, but only if the company or the organisation also agrees to waive any potential claims against them. So that's something just to consider, and it may not be appropriate in all circumstances, but again, just get some advice around it, and it may be something just to consider whether that could be a useful tool to persuade employees to accept the overall deal. And then finally, thinking about the legal fee contributions. So with a settlement proposal and a settlement agreement, the employee has to get advice on the terms and the effect of the agreement from an independent advisor. And it is usual for the employer to contribute towards their legal fees for that. The standard rate years and years ago used to be £350, but I have to say it's typically increased from that. Quite often it's no less than £500 plus VAT. So I think when you're thinking about what you're proposing, to avoid a situation where you're in negotiations with the employer and they come back to you and say, well, that's not sufficient, just think about was a reasonable amount that you can offer. And it may depend on the circumstances to what extent the employee may need some advice on this to persuade them to enter into this proposal. We move on to the next slide. On the flip side, I was just going to talk about some tricky and contentious terms that can be worth thinking about to make sure you're best prepared for any points the employee may raise in the discussions and what your position is on those, and if there's any wriggle room. So ex gratia payments, they can often be contentious. So if you're not offering enough, that can be a point where the employee seeks to negotiate with you. Like I say, ideally you want to offer some room for negotiation, but just think about what is a reasonable amount so you can get to a point of agreement sooner rather than later. Contractual payments, just very briefly, but there's all sorts of circumstances where certain payments are contractual and therefore need to be taxed. So it's just really worthwhile making sure that you understand what you're offering, to what extent the financial offer can fall within an ex gratia payment, or to what extent there could be a risk of a contractual payment, in which case it has to be taxed. And then being clear to the employer from the outset as to what you're offering, so there's not any subsequent surprises along the lines where they don't feel that you were clear from the outset or transparent about what you were proposing. References can be a little bit contentious where the employee feels that they want more than just a very basic reference. Quite often it's quite standard to give just a very basic factual reference with dates of employment and job title. But you can go beyond that. And if it helps with the negotiations, it may be that in some circumstances you do want to put more detail. Again, it might depend on your regulatory requirements, but that's something also just to be aware of, and perhaps it can sometimes be contentious. Confidentiality provisions are also something where there can often be some discussions around. Sometimes the employee may have already spoken to another employee about the circumstances of what's happened and what's led up to this settlement discussion, but you've included a clause in the settlement agreement which says they shouldn't have spoken to anybody about it. So you just may need to just adapt clauses to the circumstances to make sure they still give you that protection, but they are appropriate to what has happened in practice. And also allow, with confidentiality provisions, you want to allow typically the employee to be able to speak to their nearest and dearest about the situation to get their input in it. So you can absolutely do that. What you don't want to do typically is allow them to have that ability to speak to other employees who might be in the same boat and to share exactly what you're getting. So you need to make sure that clause gives you enough protection, but obviously addresses any concerns that the employee may raise. Tax indemnities can always be something where we often get questions come back from the other side or from the employee when they're presented with a settlement proposal, in that you want to have the ability to claim back from the employee any tax that subsequently becomes due on payments that are made, or if they're taxed in the wrong way. However, the employee, from their perspective, would typically want some word in there to say, if you do make a tax demand from me, you receive that from HMRC, I've got the ability to challenge that and the ability to have a look at any relevant documentation to allow me to do so. So that's something else just to consider. A few more points. Non-derogatory comments is another area where sometimes we see employers want to put in a provision where they require the employee not to make any derogatory comments about anybody in the organisation, and that's absolutely fine to do and quite standard. Just be aware that on the flip side, the employee will also really want some provision typically to be in there to say that the employer also won't make any derogatory comments about them. And you can change the wording slightly when it's an organisation, because they the way that they agree to that is slightly different to an individual, but it's just something else just to be aware of. And again, just get some advice on the appropriate wording. And then I'm not going to talk about affirmation letters because Sonia's already spoken about that. But the final thing just to mention is entire agreement clauses. Typically in a settlement agreement, you want a provision which says this is the entire agreement between the parties. And if anything else has been discussed, it is not binding between the parties. Now, that can sometimes be problematic if you've been having sort of discussions with the employee, making promises, and those are not then reflected in the settlement agreement. So just be aware of what it is you're offering. And if it is something you've been discussing with the employee, it should normally be in the settlement agreement to make sure that all parties are clear that that is a binding term. But again, get some advice around it. And if you've got any concerns around that, we can work out what is the best way to go forward. That's it from me. I'm going to pass over now to Sarah, who's going to talk to you some more about without prejudice and protected conversations.
Thank you much, Charlotte. And moving on to my section to finish up, I'm going to look at protected conversations, the technical side of it. And what I'm going to look at is what are the different types and why does it matter? So the different types we're going to touch upon today are without prejudice, which you'll have all heard of, and then also the section 111A type of conversation, which both Sonya and Charlotte have touched upon. I'm just going to give you a little bit more depth on what that means. There's other types of conversations that you might have with employees, such as you might describe it as an off the record or a private and confidential conversation. Those aren't protected in any way by law. Those are just private conversations, but they could be referred to in an employment tribunal. And really what's the beauty of the without prejudice and the section 111A conversation is that those conversations are entirely outside of the tribunal system. And why does that matter? Well, it matters because if during the course of those conversations, you're saying to an employee, well, actually, it's not really working out. We're looking to exit you. And here's an offer. let's talk about you leaving without us following that full legal process. You don't want that to ever come back to bite you in the form of evidence in an employment tribunal, because obviously that would be quite compelling evidence of potentially a predetermined unfair dismissal. So that's why it's important to understand the two different types and how they apply. So first of all, I'm going to look at without prejudice. Without prejudice, it's a common law principle, so it's evolved in the courts over many, many years. But the core element of a without prejudice conversation is that there must be an existing dispute. And that's going to be something that we look at in a bit more detail in a moment, because there's been lots of case law about whether or not a dispute was in existence, and therefore whether a conversation such as the one I referred to before about an exit is something that can be referred to in court or not referred to in court by the employee. The other core element of this is that there must be a genuine attempt to settle that dispute. So you have to see that both that there's a dispute, but also that the person who's communicating is trying to settle that dispute. So I'm going to take you through a few different cases. And like I say, there's quite a lot of examples in case law about this, and I think they're quite helpful so that we can understand the boundaries of the without prejudice rule. So this first one, Nomura, there was a draft settlement agreement and a correspondence between the employer and employee, and it was marked without prejudice, which is a good start. And the employer was offering an ex gratia payment. So as you'd expect in this situation, there was a dispute, and it was clear that the parties were trying to settle it. So the correspondence was not admissible in court, and it was something that was genuinely without prejudice. Moving on to A versus B. And this is a very different kind of conversation. So this was a note of an off-the-record conversation between a trade union rep and an HR team member. And it was a school, and the teacher had been aware that the school had issued a final written warning against them. And then this off-the-record conversation took place. And the question was that off-the-record conversation just off the record, but not actually without prejudice? And in this case, it was not without prejudice, this conversation. And the key reason for that was that by the time the off-the-record conversation took place, the teacher had received the final written warning. So they weren't actually contemplating litigation for unfair dismissal in that precise moment. And so there was no without prejudice protection for that conversation. The next case, the PNB Paribas case, and this was something that caused quite a stir when it came out 20 years ago, which is shocking to think it was that long ago, when there was the situation here was the employee returned from maternity leave. She believed she was discouraged from returning. She was invited to a meeting to discuss her position, and told that it was best for her and the company if she left amicably. She had already raised a grievance at this point, and she was told that her grievance would continue if we couldn't reach a settlement. So BMP thought this conversation was definitely without prejudice. They said, look, there was a dispute because there was a grievance. So that clearly shows that without prejudice applied to this conversation. However, the court, perhaps somewhat controversially, held that the employee merely raising a grievance doesn't necessarily mean that there is a dispute. Obviously, I think that in almost all cases, most employers and employees would say when it's got to the point where an employee is raising a grievance, there most certainly is some sort of dispute. But it shows that it's very much going to be fact specific, and you can't rely on the mere fact of an employee raising a grievance to establish there's a dispute, and therefore to establish that any conversations you have after that grievance will be without prejudice. The reason the court said that, they said, was that a grievance process is an internal procedure. It could have resulted in an outcome that was acceptable, and so it couldn't be properly said that the parties were in dispute. In another case, the Garrod and Riverstone management case, an employee had submitted a grievance which include references to ACAS mediation, early conciliation, and a list of complaints that they wanted to then make into an employment tribunal claim. So a meeting took place to discuss that individual's grievance, and at the end of the meeting, she was told that there was then going to be a second part to that meeting to have a without prejudice discussion. A settlement offer was presented to the individual, and the meeting concluded without any agreement on the settlement being reached, which is pretty standard for an initial conversation where you're just presenting the possibility of an offer to somebody. You wouldn't necessarily expect it to result in a resolution there and then in that meeting. And what the court said about that conversation was the without prejudice rule applied to the settlement offer part of the meeting, but not the bit where the grievance was under discussion. So you can see from that different parts of meetings and different parts of correspondence can potentially be protected, whereas other bits are not protected. So it depends what you're discussing and the purpose of your discussions and whether you're making an offer to settle at that time. And this is why when we're doing scripts for conversations, we often have an open part to the meeting and then we move to a protected part where we make an offer. And this is something we'd be happy to chat to you about if you've got any questions about that in particular. And moving to this case, Hudson versus Oxford University, and this was an individual who had been dismissed, appealed against his dismissal, and was suspended. And the university registrar wrote to this individual, and they did put without prejudice at the top of the document. But merely labelling a document without prejudice doesn't necessarily make it so. It still has to have the key components of a without prejudice conversation or correspondence. So going back to what we looked at the start, there has to be that dispute and it has to be a genuine attempt to settle that dispute. And the university registrar said, we don't think you'll be coming back. However, it would be great to find a solution, but that's not going to be possible unless you accept that a resumption of the employment relationship is both unrealistic and unworkable. And somewhat unsurprisingly, the court said, well, that wasn't really a genuine attempt to settle. Though no offer was put to this individual, it was really kind of laying out the parameters upon which the employer was willing to have a subsequent settlement discussion, but it didn't actually amount to a settlement discussion there and then. So there are a few exceptions to the without prejudice rule. And we've looked at when it will apply and when it won't apply. And these are some examples where even if on the face of it, there's a dispute and it's an attempt to settle it, it won't apply in any event. So just going through some of these examples here. First of all, it can be used to explain a delay. So often you'll be in a situation where you'll be speaking to an employee, there may be conduct or performance issues, and then that open process will be paused whilst you put an offer to them. And then there may be, in some cases, a slightly protracted set of conversations or correspondence in which you seek to settle the dispute, perhaps ask them to leave, and you make some various offers to them. So in those situations, you can explain the delay by confirming that it was for the process of settlement. You can also not have something used without prejudice if it's on the question of costs. So you might have sometimes seen documents labelled without prejudice, save as to costs. And what that means is that the correspondence or the conversation is intended to be without prejudice. However, if you're in a scenario with somebody who is making very unrealistic offers and you just cannot get to the point where you're likely to settle, and you know that it's likely to end in litigation, and you want to be able to say that they conducted themselves unreasonably, you might want to say it's only without prejudice, except in circumstances where we're going to try and seek costs from this individual. And that's when you would label the document that way. And there's various other exceptions which are set out on the slide. For example, where actually the conversation that you're seeking to disguise with the without prejudice banner is it demonstrates that you are blackmailing someone, or if there's some other impropriety shown during the process of those discussions, and the party on the other side wants to be able to evidence that poor behaviour by removing the without prejudice protection that you thought the conversation had. So that's without prejudice conversations. And the big restriction, of course, with without prejudice conversations is this idea that there has to be a dispute initially. And about 10 years ago, the government said, look, this is there's been so much case law about whether or not there's a dispute, whether something is without prejudice or not. Employers need a lot more certainty. They need to be able to speak to an individual who is underperforming, and perhaps it's just kind of low-level underperformance, but it's persistent, and they want to exit that person. They need to be able to have a conversation with that individual in which they say, actually, here's an offer to leave, or alternatively, we can take you through a performance management process. So that was how the Section 111A conversations came about. So the big pro for them is you don't need to have an existing dispute. The downside is they only apply to ordinary unfair dismissal claims. So if, for example, there are lots of complex issues with an employee, if they have protected characteristics, if they might be likely to make a claim of disability discrimination or other types of discrimination, it's unlikely that this is going to offer you the protection that you need when you're having a discussion with that employee. Again, as in without prejudice, if there's any undue pressure shown or improper behaviour, you will lose the protection. So improper behaviour might be trying to pressurise them to sign too quickly. You're meant to give at least 10 calendar days for them to consider the settlement once you deliver a settlement agreement to them. Or perhaps if you are threatening them with something that's very harsh or onerous, not just merely stating that actually if you don't accept it, it's likely that the next step will be for us to start a process with you, but instead saying, we don't see you staying here, we're going to exit you. If that's the kind of conversation you're having, you may well lose the protection that this offers. And we've just got one case on this, and this involves an employee who was asked whether he had considered resigning, and he said no. But he was told that he wouldn't have a job by the following Monday, which is certainly a pretty unusual way of going about things. And belatedly, the employer tried to claim that they had protection under Section 111A in relation to that conversation, and the employee was able to demonstrate that they didn't because it was improper behaviour. They didn't give options to the employee, and they put them under undue pressure by setting a really short timescale for accepting any sort of offer. So as we've already looked at, the pros with the Section 111A is that you don't need the existing dispute. And so it gives you a bit greater flexibility, and it can encourage genuine settlement discussions in situations where an employee is just slightly underperforming. But the major downside is that it only applies to ordinary unfair dismissal cases, so not the really complicated issues or that you might have with some employees. So that's the end of our webinar. Thanks so much for attending. We hope you enjoyed that. We've got to the end now, and I think we've run out of time for questions, and I'm sorry for that. But we do have all of our contact details at the end on the next slide, and we'll be very happy to answer any questions if you want to email us, and we'll get back to you as soon as we can. We will also be sending you a copy of the slides, so look out for those in your inbox. And just finally to say, we've got some upcoming events. We'd love for you to attend those as well. First of all, on the 18th of September, we've got our mock employment tribunal in London. We've got a series of different annual updates going on in October, and those are going to focus on the employment bill that Labour are bringing in. So make sure you sign up to those to know what laws you're going to have to be grappling with next year. And finally, if you're interested in doing some more in-depth training, have a think about our Employment Law Essentials for HR Professionals course, which gets fantastic feedback. And that's for any type of HR professional who wants to brush up on their legal knowledge. Thanks very much, everybody.